The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters because, as we say, the law matters. A better understanding of the law puts you in a better position to be prepared to protect yourself, your family, and your business, as we always say. As we present various topics, you may decide to handle some issues yourself, and if you decide you need to enlist professional counsel, we do this because we want you to be better prepared. And as a result, hopefully, so will your counsel be. Our goal is to save you time, money, and as we always say, hopefully to help you achieve the best possible results. As always, and once again, we want to welcome and thank Attorney David Bizarre from the Bizarre and Associates Law Firm in East Providence, as he provides us with his legal information, his instincts, and sometimes his fun anecdotes. So today's topic is the choices between wills and trusts. We have discussed these in the past. We've discussed estate planning and various facets of them. But questions arise about when to choose each. Sometimes it's a matter of choosing both. So the real issue ends up being, what are your priorities? And as we've done these past sessions, we've heard questions that relate to which one do I need? What should my priorities be? And we've talked about the idea about privacy. We've talked about cost. We've talked about control in various issues. So today what we're going to try to do is help review some of the issues that you might want to consider as you are planning your first time around to do wills or trusts, or maybe as you're thinking about what needs to be edited or changed or updated because situations change in life almost daily at times. So let's do a quick recap about wills and the trusts and what the differences are, a little comparison.
Sure. So people often come in and say, I want to do a will, or I want to do a trust, or why would I need a will if I do a trust? And so we always look at it and say, when you do an estate plan, there are two things that really go into it, people and property. And so we need to know a lot about the people, but for deciding about whether to do a will plan or a trust plan, we need to know more about the property. And so I'll explain to people when a will is probated versus when you have a trust, and it doesn't require probate necessarily. And so sometimes you can do a will plan and still not have to probate anything.
How's that?
And that's the question. Okay. So when we formed our great country, we thought it was really great that people could own things. And so one of the things you own is that pen in your hand. And so that pen has your name on it. It's your pen. And if you want to, during your lifetime, you could reach across and give it to me, and it would become my pen, and I'd put my name on it. But if you die with your name on that pen, you're no longer here to change the name to whoever you want it to go to. So what would happen is that pen would go to probate court. And an old partner I used to work with called probate court a car wash. And what happens is that pen goes in this side of the car wash with your name on it. And then the probate court looks at the will, scrubs your name off of it, and puts whoever you left the pen to, and it comes out the other side with that person's name on it. So the only property that has to go to probate court is property that is titled to just you, doesn't have a beneficiary or a transfer on death designation, so that the only way to change the name on that property or that pen is for probate court to do it.
So we often say, when we've started to talk about wills, if you have a simple life, small estate, and maybe you have your checking account, your savings account in joint names, and that house and the car maybe could be in both names. Can that happen? I guess it can happen.
In Rhode Island, it can now.
Okay, good to know. Then that means there's nothing that's property. I mean, in the situation that I'm proffering here, there's nothing of property to be probated. It's
possibly. So let's talk about that.
Okay.
All right. Husband and wife or a single person?
Husband and wife.
All right. Husband and wife. They own a home.
Mm-hmm. In joint.
So it's tenants by the entirety. Best protection. Husband and wife. If you own it tenants by the entirety If the husband gets sued and someone wants to put a claim against the husband, attaches the property, creditor can't do anything with the property while there's a husband and wife. And if the husband dies first, the lien goes away as to the wife. So husband and wife, best protection, and right of survivorship. So if the wife dies and the husband survives, the house automatically goes to the husband, no probate. They have bank accounts, savings and checking, joint. So one dies, it's going to go to the survivor. The husband has a 401k, the wife has an IRA. They leave that to each other by beneficiary designation. So that's protected. The car, let's just say for the sake of argument that it's in the husband's name and the husband dies. There is actually in Rhode Island a way to transfer the house to the surviving spouse so that it doesn't have to go to probate.
The house or the car? The car.
The car to the spouse, not the house to the car.
Got it.
Spouse.
Got it. So while we're talking about that, credit cards. Husband has some credit cards. Wife has some credit cards. The husband dies and has more debt, but it's not a joint account. Is she liable? So
the debt is personal to the person who owes the debt. So while I'm alive, if I have a credit card or debt that's in just my name, the credit card company can't ask my wife to pay for it. It can't ask my children to pay for it. They can only ask me to pay.
Okay.
If I die, they can't ask my wife to pay for it. They can't ask my children to pay for it. They can only ask my estate to pay for it.
If you have an estate?
So if I die with assets that are in just my name, they can file a claim against my estate in probate.
And I was just about to say, I took a dirt road there for a moment to ask you about credit cards, but if it's in an estate, then it ends up being part of what is owed or...
Correct.
Got it. Okay. When we're talking about wills, also, there was a thing called codicil years ago before we had word processors that could quickly change these things. Are those things still legal, ever used? And what are the issues that are, why would someone do that? Why wouldn't you just get another will?
Yeah, so they're legal.
Mm-hmm.
Some people still use them.
Mm-hmm.
I'm not sure why you would do that, because we have a thing now called word processing. And it's probably just as easy to change the will to reflect the changes you want to make than it would be to draft a codicil.
So I know we haven't gone through the estate portion that you want to go through, but some people have both. So let's go give us...
You're talking about the trust portion.
The trust and then a spillover or a pour over and all the rest of that gets a little bit murky. So choosing one or both. So what's the benefit of doing the estates? You talked, the trust. Sorry.
That's okay.
Excuse me.
I'm with you.
It's car and house situation.
Yeah, it's not a spouse, it's a house.
So talk about the trust, please.
Okay. So I told you about titling assets. And if it's in joint names, we're probably okay. But there is that 1 in a million chance, I guess, maybe it's not quite that number, where both people who own it jointly are in an accident at the same time and they both die. Mm-hmm. So putting that aside, what the trust allows you to do is to put assets into the trust. And so now the trust is the owner of those assets. So we take the house and we deed it from you and your spouse to the trust. Now the trust owns it. So the name on the house is the trust. And the trust never dies. So if you have a joint trust and you or your spouse die, it doesn't change the fact that the trust owns the house and that the terms of the trust will dictate what happens next. If your pen had the name of the trust on it, it would never have to go to probate court because the trust will control what happens to the pen and we don't have to change the name on that pen through probate court.
So that's one value to it. You
want another one?
Yes.
Okay. So since we can avoid probate court,
which is a good thing at times.
Yep, you save some money and hassle. You also have, it's not public. So if you go to probate court, whatever your assets are that are listed on the inventory, the public can go in and look at that and say, oh, look, Deb had a pen. So your assets are private. The process is private. There's no inventory tax that you have to pay to probate court for your assets.
Oh, I didn't know that existed.
Oh, yeah.
What do you have to do? Take a tally of all your goods?
You have to file an inventory of what the assets are that are going through probate, and they tax it. However, there's a max.
Okay.
I think it's $1,500.
Who gets the tax, David? Who gets taxed?
City or town.
Okay.
In Rhode Island.
Okay.
Every city or town in Rhode Island has its own probate court.
Okay. Good to know.
And the filing fees.
And the filing. Okay. Yeah. And you've avoided some of that if you have. Okay.
A trust, because it's not going through. However, if you have a trust, people always say, well, then why do I need a will? You need a will. As you said, it's called a pour-over will. So if you didn't put an asset into the trust or have a designation of the beneficiary on the asset, then it's got to go through probate court, just like we spoke about at the beginning. What the will does, it says, if I missed an asset, and I'll give you a couple of examples of what used to happen, then that asset gets poured back over into the trust. But it has to go to probate court to do that.
Okay. You have a couple of examples.
So what used to happen is, oh yeah, I followed your rules. I opened a new account. I put it in the trust. I did that. I did that. I did this. Oh, well, you know what happened? My client died and she had a Christmas club. Do you remember those?
I do.
Yeah. Yeah. Well, she didn't want her husband to know she was stocking money away for Christmas in the bank. And so she didn't put his name on it or any other name on it, just her name. Had to go through probate court.
Did he end up getting it?
Oh, yeah. And he got a Christmas present, too.
Oh, good. So when we're talking about the pluses, not the pluses minus, but the differences, I understand costs more to initially draft a trust than it does a will. Also takes less time to settle the issues of a trust than it does a will. It could take longer.
No,
weeks, months.
It can be a bit quicker. It depends. But probate court has to stay open for the period of time for creditors to make claims, the credit card company.
Got it.
And so you can't close it during that period. It has to stay open. You can close a trust much quicker, but if there's a lot of money, oftentimes what we're going to do is wait at least for some of it till we file the estate tax return, so that that's done. In Rhode Island, you get to pick the date of death value for the estate tax return, or you can wait 6 months for what's called an alternative value date, and whichever is more beneficial you can use.
Good. So one question that came up after we had had several sessions talking about wills and trusts and different kinds, I guess I never really thought about it, but it is very true. A will is for when you die. The trust is the only instrument, it is the instrument that lets you plan for things while you're still alive, which to address or refer to the things that we had handled before, what we talked about, who manages your finances, your kids, and everything else before you die, while you're still alive. That's an important facet.
Right. Yes. So a trust can provide for trust administration while you're alive and you become disabled. However, you still need, just like you need the will, you still need a power of attorney for assets that are not in the trust. So again, what happens is in your trust, you'll name, all right, I'm the trustee of a grantor or revocable trust while I'm capable. If I become incapable, I have a mental or physical disability, I no longer can manage it myself, I name who's the next trustee. My disability trustee, so to speak.
Control over that. That's a control issue.
Yep. And so now my next person steps in and they can manage my trust for my benefit, just like I could have before I became disabled. But they can only control the assets that are in the trust. Therefore, you also need a power of attorney for them to be able to do your financial business for things that are not in the trust.
Do people put their businesses in their trust too?
Sometimes. You might have an LLC that owns property. So the LLC has its protection, but the member of the LLC becomes the trust instead of you. And what have you accomplished by doing that? You avoid probate because the trust is the member. The trust owns the LLC, or the trust could own stock. Now, there's a little kind of accounting information that you would need to know and do if it was a subchapter S corporation, because if it's a grantor trust, it's okay, it passes through. But what happens when you die? There's some elections that you have to be able to make a QSST, way beyond what we're going to talk about today.
That's for a subchapter S?
Yeah. Just know that you want to make sure you have the correct language in there if you put a subchapter S corporation into a trust.
Good to know. And if you have children with special needs, or if you have property, and you talked about property, never mind your house, but if you have property in other states, does that automatically say better off in a trust without question? Or
I think once you start talking about multiple properties, there are so many other advantages of putting those things into a trust, including avoiding estate tax. Yes.
Is there such a thing when someone comes in and says, well, I went online, and we do say using online can be very helpful, get you started to what questions to think about, and you're going to drill down on that with some degree of detail. Is there such a thing as a tipping point where someone says, I started to do this, I wanted to, Will, David, is there something that makes you say this really isn't in your best interest? Is there one or two items that clearly tell you, no, I know you think you have a small estate. I don't even know what a small estate is considered, a small set of assets are. But is there one thing that triggers, or two things that say you absolutely need to put these in trust instead of having a will?
In Rhode Island, if your assets and you're married are over $1.8 million, you probably really need to start thinking about a trust plan versus a will plan. If you have certain situations with children, like you mentioned, a special needs child or whatever, my preference would be to create a plan with the trust that then provides for a supplemental needs trust for that child when you die, and you've picked in that trust who's going to manage the money for that child. Could you do that through a will? Yeah, but it's much, I think, cleaner. And many times, there are times where you'd want to do that through a will, by the way, but creating the supplemental needs trust for a child in a trust when you have other children who don't have those needs and might not be getting their inheritance that way. And especially if you're over that $1.8 million mark where you're going to be looking at saving estate taxes, those are some of the things that you want to consider.
So also,
and avoiding probate.
So if someone has something like a special needs trust, or has a child with special needs, and they want to, we've talked about their SSI and all the rest. If you have someone who's taking care of your the financial area of your estate, do you also need to have another lawyer in the queue? Because not necessarily someone who's good at finances. In my family, my brother is a good financial person. That's terrific. By the time they are, I want to say, saddled with or expected to deal with that, that can become very difficult. So if you have put together a plan for someone, and now that financial person is sitting at your desk, is it you, the lawyer who put it together, is it you who deals with that? Or do we have to say, you need to have another set of lawyers and accountants and all the rest to guide them through the handling of that Medicaid trust and the special needs trust and the SSI and all the rest of that?
When somebody dies, we'll help settle the trust that we created and create those other trusts. And when we create the original trust, it says who the people are that are going to be in charge. But if they need professional advice, if it's something we can give them, we do. Yes. If they need an accountant, if they don't have one, we'll help get them to one. If they need a financial planner to invest the money, we'll help with that. But usually that's all set up because it's the same people throughout, as long as they're still around, that are going to be helping with all of those things. And that's the thing with the trust is you may want to say who you want helping, and you can put that in.
So if there's a young couple and they haven't really amassed a fortune yet, but you've met with them for something else, maybe someone's starting a business. Is it ever you who would be saying, have you taken care of or thought about? Why, David, I'm 30 or something. When do you know that do you ever suggest it, and how do you go about suggesting that someone should start to think about? I mean, at my age, your age, or younger and older than we, probably have thought about our passing or what's next. But a younger person doesn't. How do you get them to start thinking about that? Because things happen.
Yeah, we do that all the time. And the real issue is when they have a child, because now they're going to worry about who's going to be the guardian for this child if something happens to both of us. If something happens to both of us, who's going to manage our money for our child? So oftentimes it can be done with a will, with a plan that has what's called a testamentary trust, which is the will itself creates the trust. It doesn't come into being until the will goes to probate. That's why it's called a testamentary trust when you die, so that there's a trust in place that has the terms of what you want your trustee to do with your money for your child.
We hadn't talked about that before, but that sounds like that's something that younger people should be aware of, because they're not necessarily thinking.
Yeah, there's usually two very important things. Who's going to be the guardian of our child, and who's going to manage the money for our child, and when do we want our child to get the money? And that can all be done in a will plan if your estate's not quite big enough yet to say, I want to spend the money to do a trust now.
So both can handle who's going to take care of a child?
The will. You can name the guardian.
Trust, though.
No, you can do a will that says, I want so-and-so to be the guardian, I want so-and-so to be the trustee. And it doesn't have to be the same person or people, but it can be.
So talking about time that you save on the other end between wills and a trust, what about cost? It certainly takes much more time to do a trust than it does a will.
Yeah.
When someone's first starting out, except if they have a child, is a will really a costly thing for someone? What's a range that someone would pay for a will?
It depends. If you
under $1,000?
It can be.
Okay.
For a single person.
Okay.
Just a will. Yeah. But when we do a will plan, because we don't do
different
just
from
a will.
What's the...
A will plan is, we want you to have a will in place in case you die. We want you to have power of attorney in place in case you live and become disabled or need help. And healthcare power of attorney, a living will, a HIPAA release, so that whoever is making your medical decisions can get your medical records if they need them. So it's a whole plan. If you're a single person and you don't have children and you're not worried about it that much, at a minimum, you need to have the powers of attorney and the healthcare power of attorney and the documents that will be there in case you became disabled.
When it comes to those documents, or among those documents, the healthcare issue and who's taking care of you, if people aren't married, they're single, they're partnered, to men, to women, men, women, whatever it is, do they really need to keep that with them when they're taking care of someone? Is the onus on them to bring that to a hospital or to a doctor, rather than just going to the portal and say, I can log in because I have access? Yeah,
so you're in the same position as anybody else. It's changed a little bit. There was a time where you needed I have the right to make the funeral arrangements. I have the right to do this. I have the right to do that. You can get married. You can choose not to get married, just like anybody else. So I always think it's important. Yes, just like if you sent your medical documents, the healthcare power of attorney, living will, and HIPAA release to your doctor, who put it in a portal that's accessible at a hospital or wherever else.
That's the key.
Any person can do that and get it. I always like to have my paperwork with me in case I need it.
Just in case. Makes sense. So we've been talking about which is more important, not that they're not both important, but how you prioritize what you have and what you do. When you were talking about the pour over wills, if someone has a trust and they have the will, we talk about updating it. Over a course of 2 years, someone acquired 4 more pieces of jewelry, a new Ferrari, and whatever it is. Are those things absolutely a good reason to go back to a lawyer to put them in a will or put them in a trust? When do you know you have to renegotiate or revise these things? When someone's building their life, their assets, they ended up with 3 new diamond rings and a car. When do you do these things? Because that could happen every other day or every other month.
When we create a will plan or a trust plan, for the things you mentioned, primarily jewelry, maybe a car, we give you a form called a memorandum of personal property that you can change, add to really at any time. So what it does is your will or trust says that I'm leaving all of my personal property to A, B, or C, or wherever it's going. However, I may do a memorandum of personal property, which is the equivalent of what my grandmother did in her day, which was to scotch tape somebody's name on the piece of furniture or whatever.
Yes.
And of course, my name must have fallen off or something because it was in the pile of dust. So I got that. But the memorandum is, I just bought a new diamond ring, 2.3 carats, whatever it is, and it's going to my niece, Jamie. So you can write that in and not have to go back to the lawyer for the personal property. If you inherited $1 million investment portfolio, you might want to go back to the lawyer to see the impact that might have on your plan.
So that memorandum, is that part of what's going to be probated too?
No.
Because even though you want your niece Jamie to get it, somebody else wanted dibs on it.
Technically, it's not. And if you have a trust, what we do is we have you sign a paper that's called an assignment of personal property to the trust. So there's no title that goes with that ring. There's no, well, there might be an ownership paper, but there's nothing that says that you can name the trust. So we have you assign it to the trust.
We've covered a lot of those nuances that people have asked about. So we hope that this has been helpful to you. You know, we've spoken about things such as the estates and the wills and the pour-overs, but at this point, we've had more of an occasion to give you some various scenarios that have come up and have come across our desk, and we hope that this has been helpful to you. We hope you'll continue to stay tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.